to place us online and to do the court cry.
Case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. We have a two-case sitting today. Our first case is 2021 P558, Fariello versus Zhao. I want to remind the council that we have read the briefs. Therefore, we're familiar with the facts and the main arguments. And I emphasize this because it would behoove you to cut to the chase. I will turn the floor over now to, I believe, Mr. Rose.
Good morning. May it please the court. I'm Alan Rose Jr. from Rose Law Partners, and I represent the plaintiff appellant, Gabriele Fariello, the purchaser or buyer in this real estate case. Let me see if I can cut to the chase here on the legal issue, Your Honor. The central question that's presented to this court is, does this case fall in the McCarthy v. Tobin and Gorin v. Royal line of cases? Or does this case fall in the Blomendale v. Imbrescia line of cases? The other side and the court below put this case into the Blomendale versus Imbrescia line of cases. We disagree. We think it fits squarely within the McCarthy v. Tobin and Gorin v. Royal line of cases. In McCarthy v. Tobin, which was decided in 1999, there was an executed offer to purchase real estate on a standard form, Greater Boston Real Estate Board form. It identified the price, the property, the deposit schedule, the way title was supposed to pass, and the time and place to close. And it required a purchase and sale agreement, which would also be executed on a standard form, Greater Boston Real Estate Board purchaser agreement.
But counsel, can I just interrupt you?
Yes.
This is not a case where there was silence as opposed with regard to the key term at issue. So why isn't this case very different from one in which we can say, oh, we'll just infer the ordinary inspection contingency in the midst of silence? There was not silence here, but a fairly firm rejection of that idea.
Yeah, Your Honor, there were 3 offers to purchase which had inspection contingencies that were not accepted by the seller. The 4th one did not have an inspection contingency, and it was accepted. At no time did Mr. Fariello, my client, demand that an inspection contingency be put in the purchase and sale agreement. And that's one of the factual issues that the Superior Court below got exactly wrong. She conflated an inspection contingency with representations and warranties. My client did not demand an inspection contingency in the purchase and sale process at any time. And in fact,
but wouldn't you agree that these warranties your client wanted were material terms of the contract, as evidenced by the fact that he wouldn't sign it without them?
No, Your Honor, I disagree with that. And the line of cases below makes it clear that where the economic terms are spelled out in the offer to purchase, as they were here, non-economic terms are subsidiary to the agreement between the parties.
Well, if they're not material, then how do you explain your client refusing to sign the purchase and sale, which he was required to as a condition of the offer, accepted offer?
Well, both parties continued to negotiate on the purchase and sale agreement after the time that was set forth for agreement in the offer to purchase. And those outstanding issues were not economic. They were not the central components of the deal. Rather, What was outstanding at that point in time was paragraph 26 and paragraph 30, in which the sellers were demanding that my client agree that he had the ability to inspect
Well,
the property.
but those paragraphs were in every single version that your client proposed to the seller. Every single one that your client proposed had those two paragraphs. So how can you say that those are unacceptable when they were in the proposals of your client?
Well, they weren't in the proposal of my client. The original.
Sure they were. Every time your lawyer, your client's lawyer, sent a proposal, it had those two paragraphs in it.
Well, Your Honor, those two paragraphs are factually inaccurate, and they are not central terms with respect to the offer to purchase.
Well, if they're not central terms, and your client said that he wouldn't sign it with them, then hasn't he simply just breached? There were non-essential terms, and he refused to sign the contract anyhow.
No, Your Honor, I disagree with that. And I think that to the extent that there was going to be a determination made about whether or not these were subsidiary terms, there should have been a limited evidentiary hearing in the court below, rather than the judge simply finding at the special motion to dismiss stage that
if there's subsidiary terms and your client refused to sign them and never proposed a purchase and sale that didn't have them, then why hasn't he violated the requirement that he sign a purchase and sale within the time required?
Well, neither side signed the purchase and sale within the time required. There were outstanding disagreements between both sides. And then the seller unilaterally said, you've got to sign by 2 p.m. on Saturday, or we're going back to the market. So, I think, the court below seems to be making a credibility determination about my client and my client's intent. Yet there was no evidentiary hearing below in the court. So, and I would submit that just like McCarthy and just like Gorin, the central economic terms were set forth in the offer to purchase. And to the extent there was disagreement about remaining terms, a limited evidentiary hearing should have been held below in order to figure out whether or not those terms somehow changed the central components of the offer to purchase. So let me just walk through the offer to purchase in this case, because I believe it's identical to McCarthy v. Tobin and Gorin versus Royal, and is not an agreement to agree, but rather a binding agreement between the parties, which should be enforceable. It was on a standard form. It identified the property, the buyers, the seller, the price, the deposit schedule, the mechanics of the delivery of the deed, the closing date and time. And it said time is of the essence. This is a legal document that creates binding obligations, similar to the cases that I mentioned before. In this case, the seller's counsel prepared the initial draft of the purchase and sale agreement and submitted it to the buyers. It was not on the standard form, but nevertheless, the parties began to negotiate back and forth on that. The standard form, Greater Boston Real Estate Board purchase and sale, is in the record at page 202. And that document makes clear that reps and warranties in paragraph 25 are contemplated, as is a buyer's rider in paragraph 30. So with respect to the reps and warranties and with respect to the buyer's rider, those are specifically contemplated by the standard form Greater Boston Real Estate Board form. And as I said, then the parties went back and forth in their negotiations, but not, we contend, with respect to the essential terms of the deal, but rather with respect to subsidiary terms. And as I said earlier, they went past the time, 6 p.m., where the parties were to agree and execute a standard form purchase and sale agreement. But both sides had issues after 6 p.m., not just the buyer. And that's evidenced in the record at page 143, where at 6:58, Sellers Counsel sent back a purchase and sale with additional changes made in it. So let me just say too, with respect to the cases that I started with, that also has to be overlaid with the language in General Laws 184, Section 15, the lis pendens statute, which says that a special motion to dismiss may only be granted where an action is frivolous, without legal support or an arguable basis in law. And this court in Ferguson v. Maxim, 96 Mass Appeals Court 385, a 2019 case, follows on that standard and says that the burden is on the defendant, the moving party in the special motion to dismiss, to demonstrate that the complaint is completely lacking in factual basis or arguable basis in law, and that the trial court should not engage in weight or credibility determinations and draw all inferences in favor of the non-moving party. And we would submit that that was not done here, and that this standard and the teachings of McCarthy and Gorin require the reversal of the Superior Court's decision. So as I said, the Superior Court committed error when it granted the special motion to dismiss because the offer to purchase contained all of the essential terms to the sale and created a binding legal agreement.
Counsel, can I just interrupt you? It's hard to say that something is a non-essential term if it's the term that in fact kept the deal from going forward. Are you now saying that it isn't? There are all sorts of things in play, and it wasn't the only thing that prevented the deal from going forward.
I think the central issue at that time related to paragraphs 26 and 30 about whether or not an inspection had been done by the buyer, my client.
I don't see how you can rely on those paragraphs when your client agreed to them or repeatedly had them in every proposal that he gave to the sellers.
Well, again, that language was originally proposed by the sellers. And yes, they went back and forth. And yes, my client at the end did say these paragraphs are factually inaccurate. But the question is,
if every proposal has terms that your client is never going to sign, then how is he willing to sign a purchase and sale? If every purchase and sale he proposes is one that he's unwilling to sign because it has those two paragraphs in it.
Well, I don't believe that the fact that he's unwilling to sign two factually inaccurate paragraphs.
But his lawyer puts them in every single proposal.
But his lawyer didn't put them in at all. The seller's lawyer did.
Every time he sends a proposal back to the sellers, it has those two paragraphs in it every single time.
I do not dispute that until the end when they say these two things are factually inaccurate. In other words, it never.
If you have a duty to sign a purchase and sale agreement, and you send your proposals, every single proposal within the time required has language that you will not sign, then how have you not repudiated the contract?
Well, first of all, these were not in the Greater Boston Real Estate Board form, and my client would sign the standard form Greater Boston Real Estate Board form. From my client's position.
How would we know that when he never proposes a standard form? Every single proposal he has these two paragraphs that he won't sign. You say he would sign that, but he never proposes that. He never offers that. He never says, here's the form, here's my signature, put your signature on it.
Well, both parties agreed to sign the Greater Boston Real Estate Board form, but the initial draft prepared by the sellers was not on the form that the parties contemplated. And yes, they did go back and forth, but on those two paragraphs, Your Honor, they are not standard provisions. And I think in order to determine materiality, there should be a limited evidentiary hearing below. And just factually, Your Honor, my clients never had the opportunity to conduct an inspection. And those two paragraphs, 26 and 30, say that they did, and they did not. So just as a factual matter, those two statements were inaccurate. So let me just go back to where I started, because I see I'm short of time.
Very short.
I don't believe that there's any way that the court should conclude that this case falls within the Blomendale line of cases. Rather, it fits squarely within McCarthy and Gorin, and we would respectfully ask that the decision below be overturned and that the case be sent back to the Superior Court.
Can I ask one last question?
Yes.
Have you recorded the notice of appeal?
Have we recorded the notice?
Has the notice of appeal been recorded in the Registry of Deeds?
I do not know the answer to that, Your Honor.
Okay.
We can certainly send a letter to the court with that answer.
I'd appreciate that.
Thank you.
Counsel, thank you very much. We will now hear from Attorney Richmond.
I was just unmuting myself. Thank you, Your Honors, and may it please the court. My name is Larry Richmond. My office is in Wellesley. I know Your Honors are familiar with the brief, but I know that this is a public record and other people are watching. I represent Denise and Gavin Grant, who are not the original defendants in this case. Mr. and Mrs. Grant are individuals who purchased the property in question from the original sellers, subject to the list pendants appeal. And we were allowed to intervene as party appellees in this case. I feel very comfortable with the brief that we have submitted on behalf of our clients. I do not have very much to say. I think the cases are
Counsel,
well.
can I?
Yes.
Can I interrupt you? You've set this up as there was no meeting of the minds. Why isn't it more accurate to say there was a meeting of the minds, but that meeting of the minds was repudiated when they refused to sign with that term in it?
I think that's a good, sophisticated legal argument, Your Honor. I hadn't thought about it that way, to be quite candid with you. You know, the way that I was looking at this case was, and what I was prepared to say, and I'm not trying to dodge the question, is that we thought that when Judge Hogan ruled that the continued demand for warranties by Mr. Fariello demonstrated no meeting of the minds and that negotiations were made imperfect. I mean, every time he was asking for these promises about the property, from square one, it was made very clear that there would be no inspections, and he was trying to find a crack in the wall to kind of find his way through. The thing that my brother didn't raise, and what I think is important, and I'm not casting shade when I say this, is the fact that there were actually 5 offers. There was an offer that was submitted after the timing of the P&S expired. There was a 5th offer, and that was not even brought to the attention of the trial court in the initial hearing by Mr. Fariello's, lower court counsel. That's something that was raised. I think that was a very, important fact. And, to the extent, when the verified complaint was filed seeking the memorandum of list pendants, I think, when Mr. Fariello signed it, I think he says that there are no material facts submitted. I mean, we think the fact that there were actually 5 signature documents, not 4, we think that is a material fact, that should have been admitted. We do not think that Judge Hogan abused her discretion or committed any error of law in ruling that 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 the representations that the Mr. Fariello was continuing to demand were refused from the very beginning. The only other thing I wanted to focus the court's attention on is the issue of, attorney's fees from my clients. And I would just call the court's attention, and I know my brother submitted his reply brief on this issue, but there's I guess it's an unreported decision, although it shows up on Westlaw. It's Town of Ware versus Owners Unknown, 99 Mass Apport 1116. And it states, and it talks about the fact that where an intervener was allowed to get their fees paid on a finding of a frivolous appeal, it only makes sense that an intervener would also be allowed to recover their attorney's fees under the list pendant statute. And the case law, which specifically entitles appellate fees under circumstances. So to the extent, if Your Honor finds that Judge Hogan did not make any abuse of discretion or error of law, we believe that my clients are entitled to attorney's fees. I don't have very much else to say.
Counsel, part of Mr. Rose's argument is that even if the judge got it right, that the complaint failed as a matter of law, it was still not a proper subject of a special motion to dismiss unless it's frivolous. The key difference being one of entitlement to attorney's fees. How is this case not only invalid as a matter of law, but frivolous?
I think it's frivolous because, let me think this through for a minute so that I say the right thing. I think the case is frivolous because it's clear that there was no binding agreement between the parties. I think the case is frivolous to the extent that Mr. Fariello neglected to include in his complaint signed under oath a very material fact, which is the fact that after the expiration of the PNS date, a fifth offer was submitted, which I think in and of itself shows that we're back at square one. I mean, that information, I think, in and of itself, I think is striking. I think that the trial court, who reviewed these pleadings and relied on these pleadings and heard the arguments, made the determination that the appeal, that the list pendants should not be allowed. And I think the court, followed the correct standard in that respect, because every single document, as Judge Ditkoff pointed out, every time a document came back, it contained this information that my client's sellers, that the sellers just simply wouldn't agree to. And Mr. Fariello knew that. And one PNS, two PNS, three PNS, four PNS, then another offer. I mean, that resets the clock in and of itself. So I think that while I don't hold myself out to be, someone who is a 24/7 real estate lawyer, I don't get
how making an offer means that you accept that you didn't have a binding contract before. I mean, at that point, he knew that the sellers weren't going to go forward. So if he can get them to do a new offer, then he would. Obviously, if it had been accepted, that would have been the end of the old contract. But I don't see why it's inconsistent with saying we got a deal, but here's a little more money. Here's a different contingency. Hopefully get this thing moving.
I don't like to say I would disagree, but I mean, I just look at it differently, Judge.
You can disagree.
Because I think from the totality of all the facts, when you look at everything together, this isn't a situation where after the PNS is signed, there are cases like where they discover that there was like an unforeseen, site condition or something like that, and they have to go back and figure something out, or they have to make some kind of an adjustment because there was a title mine of some sort, some type of undischarged whatchamacallit, a mortgage or whatever. I mean, I guess I would just look at it differently, but I would leave it to your honor's acumen on that issue.
What do you think we do? Oh, I'm sorry.
Just a quick follow-up. Isn't the difficulty that once you start talking about the totality of the circumstances, you're into fact finding, which is not generally what we encourage when we're evaluating either lease pendants or whether an action is frivolous?
Judge, I'm not trying to be fresh, but I'm not sure I understand the question.
Well, you said, you got to look at the totality of the circumstances. And when you're on appellate review, that sets off, the bells in my head. Well, isn't totality of the circumstances more of a fact-finding function? And doesn't that kind of mean that we're not in the land of frivolousness and we ought to be looking at this lease pendants more carefully?
Maybe I shouldn't have used the word totality of the circumstances because, in terms of setting off bells, I think what I was trying to say, Judge, was that when Judge Hogan considered all the information before her and all the various documents, and that she made the determination, she had, her standard is she has to decide whether or not, in the first instance, the claim is frivolous. And she made the determination based on what she reviewed and what was before the court. I mean, and that was her, she is given judicial discretion to make that determination. I'm not trying to step back or dodge your question, Judge. I mean, I
know you're not. Okay.
What do you think we do if we decide that the complaint fails as a matter of law, but it wasn't frivolous? Then what do we do?
Good question.
Thank you.
I will answer the question candidly, not knowing what the power of the exact 100% power of the Court of Appeals is. I guess one option would be I've seen cases where the courts dismiss cases. I can't remember the exact context, but I think I've read appellate decisions where they've said, we've heard all the arguments of the parties, but we dismissed the case on these other grounds. I can't remember what the circumstances are. I've seen some appellate cases, I think, where they have said things like, we send the case back to the lower court with an instruction that the matter be, decided on summary judgment or something like that. Or I don't know if I've seen one that says we order summary judgment to enter. I say this not trying to sound foolish, and I don't want your honors to think that I'm a neophyte. I'm just trying to think. I think there are options. I think I had a case before the appeals court a couple of weeks ago, and a similar question was asked on another case on something like that. I can't remember how the lawyer answered it, but I mean, I think that, this court certainly has the ability, if based on all of your collective experience, you agree the case should be dismissed, but if there are other reasons, I think that the court does have some, I'm not going to use the word superintendency powers, but I think you do have the ability to instruct a trial court judge to maybe enter certain findings or to hold a separate proceeding based on your determination. Here, I still feel that the judge did not abuse her discretion, but, and please don't, I hope nobody is laughing at me if I'm suggesting things that you're not allowed to do. I'm just trying to think, what the other options could be. I mean, it's a good question.
Do either of my colleagues have any more follow-up questions? Hearing none and hearing you say that you've said what you want to say, tell me if I'm wrong.
I'm good.
That concludes this case, and the case is submitted. Thank you both very much.
Judge, thank you for the ability to appear here from Rentham today.
The case is now being recorded.
Thank you very much. We are back with our second case of the day in this special Zoom sitting. That is 2021 P835, New England Preservation and Development LLC versus Town of Fairhaven. I would remind the parties that we have read the briefs. Therefore, we are familiar with the facts and the arguments. I say this because to the extent possible, we urge you both to cut to the chase. And with that, I will turn over the floor, I believe, to Attorney Rosenberg.
Thank you. Good morning, Your Honors. May it please the court, Aaron Rosenberg on behalf of the appellants, New England Preservation Development LLC and Zachary Mayo. I'll refer, as we have in our papers throughout, collectively to the two appellants as NEPD. Your Honors, the main question in this case is whether the trial court correctly applied the high legal standard applicable to the Town of Fairhaven's special motion to dismiss, which was pursuant to the Liz Pendon statute, which required the town to show that the claims in the case were frivolous. And NEPD asks this court to reverse that trial court's order, allowing the special motion primarily for two reasons. One, because the claims as pled and sworn to are not frivolous, because NEPD alleges breaches of the implied covenant of good faith and fair dealing that occurred during the first year of performance of the contract.
Okay, counsel, I'm going to cut to the chase and ask the question we just asked in the previous argument. This is pure hypothetical. Were we to determine that the complaint failed as a matter of law, but was not frivolous, what would be the proper relief that we would grant here?
I believe that if you found that it was not frivolous, that you would need to reverse the trial court's order, because that order was solely on a special motion to dismiss pursuant to the Liz Pendon statute, which has a very specific and very high standard.
I understand that, but why drag this out if it fails as a matter of law? And the only difference, tell me if I'm wrong, between the two types of motions in terms of practical consequences is the issue of attorney's fees. Why shouldn't we do something else?
Well, so I believe you are correct that from a practical standpoint, were the motion to be allowed, the difference is the attorney's fees provision, which I don't think is insignificant. So that would obviously have to be dealt with, because obviously the town would not be entitled to attorney's fees on a 12b6 motion. But I think that the analysis, first of all, the arguments would need to be made differently. The trial court's analysis, and frankly, this court's analysis of the level of pleading and the inferences that the plaintiff would be still entitled to. I think it would be a different analysis, and one that has not been done by the trial court. So I don't think it's as simple as just saying the trial court allowed one type of motion, and we're going to perhaps find that that might have been incorrect, but we think had another motion been brought, it would have come out a different way. It's just not what the parties argued. It's not what the trial court examined, and frankly, it's not how we've presented the case at this point to this court. So like I said, there really are two reasons from our perspective that the court should reverse the prior order. One, because the claims are not frivolous, and two, because the order resolved factual disputes improperly at this stage of the case, which would be the case, and this goes back to your Honor's question, the factual resolutions that we say the court made would be improper on a 12b6 motion, as well as a special motion to dismiss. I think it's worse, for lack of a better phrase, when there's a frivolity standard involved, but I think it would still be improper at that stage. And I'll get into
counsel, just diving into the facts where I think you were about to go. It's uncontested, is it not, that by a certain date, your client was supposed to get a commitment on financing. And it's, tell me if I'm wrong, it's clear what it got by that date. A separate issue of whether or not it reported that, but in terms of what it claims was a complying commitment, why isn't then that just a question of law, whether what it obtained by that date met what the contract required?
Because I believe there's a pretty hotly disputed issue about what the parties meant by that language and the intent of the parties. Primarily, I'm talking about the part of Rider A that requires NEPD to notify the town when it has obtained financing commitments. That's what I believe Your Honor is referring to. So I think there's a factual question, especially where the town is arguing that that language means something different than it says. The town argued and the trial court found that notify the town when it has obtained financing commitments actually meant provide a binding contract from a lender that they will fund the project. That's not what the contract says. So particularly where one party is attempting to essentially alter the language of the contract and the other party here, NEPD, obviously disagrees with that, I think that's a factual dispute that can't be determined on a motion like this.
Well, counsel, it's been a while since I read the record on this case, but my recollection is that for 80% of the financing, what was there was a letter from a bank or some other financial institution saying, well, we don't think there's a problem. How is that a commitment for financing under any reasonable way that term is defined?
Well, I think that the letter, which is in the record, I believe at RA 104, from the financing partner of NEPD that I think you're referring to back in, I think, February of 2020, which I think it does a little more respectfully, Your Honor. It says, I am the financing partner. Here's who I am. Here's my experience. Here are my assets. Here's where I'm going to get the money from various places. Here's who I've spoken to at those places to make me confident telling you this. And then at the end, it even says, let me know what else you need to confirm my commitment to the project. So where the language of the agreement does not say that, that NEPD needs to provide a binding loan commitment, I do think that satisfies the requirement there. Again, also keeping in mind, and I don't want to harp on it, but I do think it's very important. The case has to be frivolous for this motion to be allowed. And that is an extremely high standard. It requires the lack of any factual basis and any basis in the law. So if it's an argument, if it's a determination that the court is making, the trial court, weighing the arguments that exist on both sides, by definition, it's not a frivolous argument. And
in your view, how much is enough to fund the development of the project? Like what kind of number in your client's view did you have to get to?
I'm just looking at the letter.
I've got the letter, but the contract says obtain financing commitments sufficient to fund the development of the project. It doesn't specify what that is. And I'm wondering what your client's view is of that, what the neighborhood of that number was.
The reason I'm looking at it, Your Honor, is I don't know off the top of my head exactly what that number was. I do believe it would be reflected in the record, but I'm having trouble locating it. But I'm having trouble locating it, and I apologize for that. But
Council suggests it's about 4.6 million. I just don't know whether you agree with that, or if you think that's radically high or in the neighborhood.
I'm just not comfortable giving you a straight answer on that, and I apologize, Your Honor, because I just don't have that before me. But again, I do think that the standard that applies in this case would come into play even on a question like that, because if we're talking about, first of all, I don't think that's the primary argument, or as I understood it from the town, for why the financing letter was insufficient. It was closer to, as Justice Milkey was saying, which is that that it requires a binding contract from a loan commitment letter signed and binding, to the bank. Even on the question of whether enough is enough, if the parties are fighting over how much they would have had to get, I still think that would create a factual basis in the law that would make it a non-frivolous claim. Just to briefly, because I see my time is progressing here, I just want to briefly explain the conduct that we believe constituted the breach of the implied covenant during that first year of performance. And that is really the key here. Is, as I understand the town's argument, it is primarily that, and this is what the trial court held explicitly, the town had the right to terminate after 1 year. The town did that properly, and therefore it cannot be liable for any breach of contract or the implied covenant, and any such claims are frivolous.
Let me ask you this: the breach of the implied covenant of good faith, would that get you specific performance, or would that just get you damages?
I believe that would get us damages,
So
normal contract damages.
So it wouldn't support a lis pendens.
Well, I would say that the standard on filing a lis pendens, whether title to the land is implicated by the contract, or excuse me, by the dispute. I would propose that a claim about the sale of the property and the appropriateness with which that sale was done would still impact the property. But I understand the point that Your Honor is making, and I would just point out that just not impacting the property may be grounds, if that were true, for the town to have the lis pendens dissolved. It would not be grounds for a special motion to dismiss. That is not enough for a special motion to dismiss to be allowed. That requires frivolity. Those are two different motions. And I understand that the trial court here did both allow the special motion to dismiss and enter an order dissolving the lis pendens. So while I think the lis pendens would still be appropriate, that would not be a sufficient basis to allow a special motion to dismiss. And
you've talked a lot about financing, and in your brief as well. But I didn't see much in your brief about the historical registry requirement. How is there an issue that your client complied with that requirement?
There is an allegation in the amended verified complaint that NEPD filed an application to have the property placed on the.
But the requirement was to notify the town in the contract.
That's correct, Your Honor. And there are, I think it is fair to point out that specific requirement, according to the record, was not complied with at the end of the day entirely. But again, I think it's relevant to realize that what we are saying is during that same period, and even prior to that, the town had taken conduct and taken actions that breached the implied covenant, and A, create non-frivolous claims, and B, impact, I believe, the town's ability to then rely on the failure to satisfy a condition precedent, which is what the town says each of these are.
I want to get clarity on what you're saying. Are you saying that the town's non-compliance with either the express terms of the contract or the covenant of good faith and fair dealing prevented your client from meeting these conditions?
I don't think I can say that it prevented it in the sense that it made it impossible. I do think it certainly made it more difficult. Every time, or virtually every time, I shouldn't say exactly every time, but many times during the course of performance of the requirements of Rider A, when NEPD would submit items that it believed and still believes satisfied major elements of this contract, the response was to kick it back and say, actually, no, you need to give us more and more than what the contract says. And if you don't do that, we're just going to terminate the contract. So I think that the cumulative effect of that repeatedly happening, combined with asking for additional things that weren't in the contract at all, like binding contracts with an engineer, a timeline, which NEPD still provided, but were not in the agreement. The cumulative effect of that was to make it much more difficult for any PD to comply, in addition to constituting breaches of the implied covenant of good faith and fair dealing. So, Your Honor, I wouldn't say prevented. It was not impossible from my perspective, but it was made significantly more difficult from our perspective. I want to briefly point out, I see I have about 20 seconds left. I said that the trial court improperly resolved factual issues. One of those factual issues, we believe, was the meaning of the financing provision, like you said, Your Honor. But another one was at page 15 of the order RA 239, essentially resolving the main issue in the case and stating that this was all NEPD's fault. We think that was improper on a special motion to dismiss.
Do either of my colleagues have any follow-up questions? Seeing none, thank you very much. We will hear from Attorney Curhan.
Good morning. May it please the court. Dana Curhan for the town of Fairhaven. I think the elephant in the room is that New England Development never obtained the necessary financing. Condition B required the plaintiffs to notify the town within 180 days of the execution of the agreement when it obtained financing commitments sufficient to complete the project.
How are we to know what that means? I mean, there's a spectrum from an expression of interest to finance to a Loctite, absolutely enforceable signed agreement to finance. Where along that spectrum was this particular requirement?
Well, I think there has to be a commitment from some institution to finance the project.
Why does it have to be an institution? Why can't it be a person who just has enough money to fund the project?
Well, it could be that.
Well, then why isn't that what we have here? We've got this guy. He says he's got $2.7 million and another $3 million of real estate with no debt. Seems like enough to fund the project, and he says he's committed to it.
Are we talking about the Raymond Green letter or the?
The Bart Busnick letter of February.
Okay,
the one that your friend was having us look at.
So the problem with the Bart Busnick letter is that he said, look, I have a guy, didn't say who the guy was. I have a guy at Cambridge Trust, and they said it would be no problem to obtain financing. And we need to put down 20%, which is 500,000. And but nobody from Cambridge Trust ever made that commitment.
But he also says he's got enough money to fund it himself. Sure, he'd like to use a bank, but when he's got the money himself, why isn't that enough?
Well, I mean, he didn't actually make that commitment. He talked about Cambridge Trust, and then in discussion with town council at about the 1-year anniversary, he said, "Look, this is I'm not going to commit." He said the condominiums in Fairhaven just don't. You can't sell them for enough to make this project work, so I'm not going to commit. And it was only at that point that town council said, look, we're pulling the plug on this. And not just this, for a variety of reasons. There was not only the loan commitment, but condition E said there had to be a letter of credit sufficient to guarantee the completion of the work as shown on the approved plans. So
I thought that the termination letter was sent 9 days before town council had the conversation with Miller's River.
there was a discussion about, see, they never, Rider A required them to file plans. They never really, condition A required them to file plans. So they said, you know, we want plans or somebody who's going to do this financing, or at our next meeting, we could terminate this. But they didn't do it on that basis. What they did is after Mr. Busnick pulled out, they said, look, you don't have the financing, you haven't met conditions. B, C, D, or E. So, we're terminating. Now, there were further discussions. Town council suggested that, look, if you get financing, if you get a commitment, go before the selectmen and we could modify the contract or give you an extension or do something for you. I mean, the town was doing everything it could to save this deal. But ultimately, none of the conditions in Rider A were actually met. That's the problem. The judge found that, that there was a genuine issue as to the permitting issue. Maybe the town, I won't say impeded, but didn't necessarily cooperate in getting the necessary permit. So,
Wait, can I ask you a question on that? What does it mean for the town to agree to assist the developer with the permit applications? And why isn't that putting the town into a very dangerous conflict of interest?
I'm not sure what that means, and I think the judge did not rely on that. The judge expressed some skepticism as to what New England Development had done. I suppose if you had a nefarious town that didn't want to develop this, or maybe wanted to go take a different deal, they could have used that to sabotage this agreement, but that's not what the record shows. And ultimately, the things like putting it on a historical commission or getting it registered as a historical property, and most importantly, the financing. It was really fatal to New England Development's claims. Fairhaven wanted to get this done. This school is sitting empty, and they want it developed and preserved. And again, the elephant in the room is financing. They just never got it. They had people who expressed interest in it, but were not willing to make the financial commitment.
Counsel, to the extent the plaintiff has alleged that the town made it difficult by dragging its heels and doing other things, and in fact had made a decision that it didn't want to support the project, why isn't that enough at this stage to survive?
Well, the breach of contract claim fails because none of the other conditions were met. And that's pretty clear from the record. And the judge, had this before him. As far as the breach of the covenant of good faith and fair dealing, I think you have to show some, maybe something approaching what 93A would require, some real misconduct and some real sort of affirmative steps taken to impede the contract, which we really don't have in this case. We have a few allegations that maybe they were a little slow getting the permits or helping with the permits. But I think New England Development wasn't helping itself. They were pretty slow in making the necessary applications. And they raised that sort of as an excuse to why they hadn't done what they needed to do to get the permits. I think we alleged that it was not the town, that it was New England Development. The judge said, well, the town is probably right, but I'm not gonna use this. I'm not gonna rely on I think it's Rider C, C or D, whatever the permitting. And the judge relied on the other three reasons. And again, where do you get anything approaching a financial commitment from anybody in this case? There's no letter from a bank. There's no letter from a developer. There's no there's no performance bond with financing sufficient to, and New England Development concedes this, by the way. There is no bond as required under Rider E. So I think the judge was certainly within his rights to say, this doesn't meet any of the requirements, and dissolve the Liz pendants and dismiss the claims.
What,
Do you
Go
agree
ahead,
with your
Jeff.
friend? Do you agree with your friend that the breach of the implied covenant would only have damages as a remedy?
That would have damages, because I don't think you can grant a Liz pendants on that, because I think the town has a right, if there's an opportunity to do something with this property, I don't think that should be tied up on a breach of the covenant of good faith and fair dealing in the absence of a breach of contract.
well, it is a breach of contract if it occurred. I mean, it's a breach of an implied term in the contract.
Well, I mean, I think that there was enough of a breach of contract by New England Development where they really can't recover for a breach of contract. If they didn't provide the financing or the bond, and they didn't have this, and they didn't provide notice that they had applied to have this registered as a historical building, they can't recover on a breach of contract. If the argument is then, well, you can have a breach of the covenant of good faith and fair dealing without a breach of contract, that's a separate issue. And, usually you have both.
Okay, counsel, on the same question we started with, hypothetically, were we to determine that the complaint fails as a matter of law, but is not frivolous, what do we do?
I think that only affects the legal fees. But, when we talk about frivolous, we talk about something that is defined by statute. And the statute talks about devoid of legal support, devoid of factual support, or subject to a defense. And I think we have all three in this case. But again, the issue would probably go to legal fees. I don't think there's any case law talking about that in Massachusetts. Unless there are any further questions, I will leave the remaining points to the brief.
Looking at my colleagues, I am seeing none. Thank you both very much. The case is now submitted.
Thank you.
Your honors.